Welcome. Thanks for joining us. I'm going to start off with a few MAT updates, really just one MAT update, but I really want to thank all of you for really successful spring short courses. We just got back from being on the road and we had a lot of fun, so thank you for that. Next up for events, we have our Town Law Review, which is June 5th at Rockwoods Event Center in Otsego. It's a really great opportunity to hear from township attorneys. It's $75 per person. I really encourage you guys to get access to that. A lot of great information, a lot of good conversation, questions answered. So I really think that's a really informative event. So put that on your calendars. But today we're going to be talking about a topic that may not seem exciting, but it comes up often when I'm talking to township officers. And it can have a lot of consequences for townships if you don't know much about it. And that is to properly classify workers as either employees or independent contractors. So we're going to talk about key differences between employees and independent contractors, the IRS's 3-factor test, misclassification scenarios, and applying these concepts to common township roles. So here is my information. If you have questions, send it in the chat and I will take a look at that throughout the presentation. Otherwise, my contact information is at the bottom of this slide, and you can reach out to me at any time. I went with a mystical theme today, so there's a lot of mystical creatures just for fun. All right, so why does it matter? Why do we care, right? That's always a question I want to ask first and foremost, but whether someone is considered an employee or an independent contractor can make a pretty big difference for everyone involved. The classification affects who is responsible for things like taxes, insurance, workers' comp, benefits, and retirement plans, etc. It also impacts obligations related to minimum wage, overtime, ADA compliance, work safety, leave benefits, paid leave, those kinds of things, and even liability if things go wrong. So how a worker is classified really determines how much responsibility the township might have towards that person and what rules apply. For townships, getting the classification is really important. It's not just about the title that you give someone, it's about the actual relationship that you have. So you may call someone an independent contractor, but in the eyes of the law, they would be considered an employee. So it's really important to understand what that means rather than just labeling someone an independent contractor or an employee. You have to know where they actually fit. And that's where things can get tricky. In some cases, it's helpful to check with your attorney or another legal professional for guidance to ensure that you're treating someone the proper way. If someone is an employee, the township is responsible for withholding income taxes, Social Security, Medicare, providing workers' comp and unemployment insurance, following minimum wage and overtime laws, meeting ADA compliance, leave requirements, safety requirements, and handling liability for their negligence. But if someone is an independent contractor, they pay their own taxes, they provide their own insurance, they have their own equipment, they take on their own risks, legal risks and profit loss risks. So classification has an effect on a lot of things. And remember, you don't get to decide what a person is classified. It depends on their actual working relationship. And the IRS uses different categories to help determine whether a worker should be classified as an independent contractor or an employee. And they recognize many types of employees. So today we're going to focus only on the ones that townships are more likely to come across. All right, let's dive in. Independent contractors. I kind of see them as like a wizard. So I put a little wizard guy there because you tell them to get the job done and they get it done, and you don't meddle into how that's done. It's kind of like magic. An independent contractor is someone who runs their own business and offers services to a broad range of clients, or could offer services to a broad range of clients. According to the IRS, the general rule is pretty simple. A worker is considered an independent contractor if the person paying them only controls the result of the, or only chooses the result of the work rather than how it gets done. So independent contractors are self-employed. They have freedom to run their own business in their own way. They're responsible for delivering results, but they decide how they get there. They handle their own taxes, they provide their own tools, they carry their own insurance, and they are the ones responsible for making sure they're following laws. So if something goes wrong, they're typically responsible for that as well. It should look like you're hiring an outside service provider more than you are hiring someone to work as an employee for your business. Again, simply calling someone an independent contractor doesn't make that true. So there's factors that determine what that relationship is, and that's everything I just listed, right? Running your own business, offering services to the public, and delivering results, not following instructions given to them specifically by the township. So you define the outcome, but you don't control how the work is done. Like a road contractor or an IT consultant, those kinds of things, you ask for them to get a job done, and they do it. You don't tell them when they work, how they work, and how they should behave throughout the process. All right, an employee. The IRS recognizes several types of employees, but for today's purposes, we're focusing on two: common law employees and government workers. Common law employee is basically anyone who works for the employer and has control over how the job is done. It's a pretty broad definition, and it covers most workers. If the employer controls things like how the work is performed, scheduling, tools that they use, or aspects like someone's appearance, what they're wearing, that person is probably an employee, not an independent contractor. Most people working for governments fall into common law employee categories, but there are obviously some exceptions. Elected officials, appointed officer, emergency responders, and election workers are still employees, but they might follow into different categories, different rules. The special rules often affect how taxes are handled. For example, most employees have Social Security taxes withheld from their paycheck. However, government workers may be exempt if they participate in a qualifying system like PARA. Because there's a lot of nuances to who qualifies for those programs and that kind of thing, you can always reach out to PARA and double check, or work with a tax professional when you're uncertain about how an employee should be taxed or classified. But overall, the rules for an employee is someone who is controlled by the township, someone whose work is controlled by the township. They are scheduled, they have to follow policies, they have to follow the direction of the township. The township would control how the work is done, when it is done, and what tools they are using. If they're doing that, that person is likely an employee. And it's important to note that most workers are presumed to be an employee unless it's shown that they're otherwise not. So let's talk about the three-factor test for an employee that the IRS looks at, and that is to figure out whether someone is truly an independent contractor. So the IRS will look at the working relationship using behavioral control, financial control, and the relationship of the parties. So I'm going to walk through each one of these. All right, behavioral control. does the township control how the work is done? This factor looks at how much control the employer has over the person doing the work. The key question isn't whether the employer controls work day to day, it's whether they could control the work. They have the right to control it. So if the employer is only concerned with the final results and leaves the details to how the work gets done up to that worker, that points more towards an independent contractor relationship. But if it's the reverse, then it's more of an employee-employer relationship. Training is another clue. So if the employer is training the worker on specific methods of procedures to follow, that usually means that they expect the work to be done in a particular way. Because it's a level of direction that suggests that you control how they behave, which would be an employee-employer relationship. So indicators of being an employee are that you're giving detailed instructions, you're requiring specific methods, you're providing that kind of training, and you're dictating hours and location. If a person would be more considered toward that independent contractor side if the township only defines the final results, and then the worker decides how they achieve that result. Financial control is the second aspect of this. So financial control asks who controls the money aspects of the work, the finances. This looks at how financially independent that worker is. Does that person who is providing the services have control over their own investments, expenses? Do they have a chance to make a profit or a loss? If a worker has made significant investments in their business, that's a good sign that they're probably an independent contractor. Of course, there's no set dollar amount as to what a significant investment is, but if someone's bought their own tools, equipment, other business expenses, it shows that some level of independence there, and some level of financial risk, which is what this element is getting towards. If they're paying for things out of their own pocket and not getting reimbursed, that's a good sign. If that suggests that they're making decisions about how to do the work, choosing between different options and taking the financial impact of those choices. So if they're hiring people, that's obviously a good sign that they're an independent contractor. If they are purchasing equipment without reimbursement, right, those kinds of things. So when you're looking at financial control overall, if they're more leaning towards the employee side, if the township provides the tools and equipment, expenses are reimbursed, and they're paid at a steady wage with no financial risk to the project. And if they're a contractor or more leaning towards the contractor aspect, they would have investments in equipment, they pay for their own expenses, and they could make a profit or a loss. So there's more of a risk there on their behalf. And then finally, relationship to the parties. So what does the relationship look like overall? This factor looks at the overall relationship between the employer and the worker to help figure out what kind of arrangement this really is. If the employer is providing benefits, that usually points to an employee-employer relationship instead of an independent contractor. And again, if they're providing tools or equipment, that's probably a sign that they're an employee. Written contracts can offer helpful clues to whether this person is an independent contractor or employee. However, having a contract doesn't automatically make someone an independent contractor because the details of what of these classifications matter, of these this three test matters. A contract could just as easily describe an employee relationship, but when a contract is structured in a way that classifies them as an independent contractor, then it leans more towards that. It's more evidence of that. Obviously, this isn't a complete list, but the few good signs that a person would be an employee would be receiving benefits, they have an ongoing relationship, they're subject to the township's policies and rules, employment policies, things like that. They're more of a contract relationship. If there is a written contract, they work for a set project or a set time frame, they provide their own insurance, and they're not treated like staff. They're not expected to be there 9 to 5. Remember, a written contract helps, but it is not the deciding factor on its own. However, if you have no contract, it's much easier to slip into that employee-employer relationship, dictating when and where a person shows up and how they do the job. So a written contract is always a good way to ensure that you're leaning into that independent contractor role. All right, misclassification. Let's talk about the risks here, because getting classification wrong can be costly in certain circumstances. Misclassifying someone as an independent contractor when they're actually an employee can have financial penalties and legal issues. So since employees are entitled to certain benefits, you could hurt the worker as well. State and federal government expects employers to regularly withhold and taxes for employees, and they can impose penalties if that doesn't happen, even if you were unintentional about it. Not having a written contract, that's where this can come into play, because that can make things even more complicated. It can be tough to prove that a worker was truly an independent contractor, is what I'm getting at, because they're always going to be considered an employee unless you move them over to the independent contractor side. So a worker might claim that they were actually an employee because there was no written contract that said otherwise, and it wasn't clear what the relationship was. Those 3 factors weren't obvious. And then that employee might claim that they should have received all of the related benefits to being an employee. If the township can't show that the relationship was meant to be a contractor arrangement, then they could end up being responsible for benefits, unpaid taxes, penalties, and claims of damages, things along those lines, whatever it may be that's come up. Even if you do have a solid contract in place, that's not necessarily the end of it. You also have to be careful not to treat the contractor like an employee. That means you can't direct or control how the work is done in any significant way. You can't tell them when they need to be working, what time, how often. You should make sure that everyone knows that when you're working with a contractor, there are boundaries to those relationships, and you shouldn't overstep what those look like. And it can be easier, or that can be harder than it sounds. People want to naturally fall into a managerial role in the same way with a contractor as they do for their employees. But if you want to maintain that true independent contractor relationship in the eyes of the law, you need to keep an eye on those habits and make sure that you understand that there is a difference, and that difference can change just by behavior rather than what the contract says for how you're classifying someone. All right, let's talk about common examples for townships. So townships are unique because they lean on elected officials and volunteers to get things done in many ways. Since they don't usually have staff members in the ways that cities and counties do, they aren't always used to the ins and outs of being an employer, right? It's a kind of strange role for townships to take on. I know a lot of townships prefer using independent contractors, but workers mislabeled as contractors can be a dangerous route, and you can't do that just to avoid the extra paperwork of someone being an employee. All right, so let's talk about election judges. Election judges are always treated as employees. Under federal law, election workers are considered common law employees. Though there can be special rules for tax withholding, townships might treat the tax treatment of election workers differently, but because election workers are always considered employees, they should never receive 1099. If a tax form is used, it should be a W-2. Since townships have different options for how they handle taxes for election workers, it might be a good idea to consult a tax professional if you want to go a different route or if you want to get an opinion on the best route that works for you. If you have option B, clerks and treasurers, that means that they are appointed. It is not an elected role. Then they're treated more as employees. In those townships, the positions are no longer elected, so they are appointed by the board. And of course, if you want to approve that option, it has to be on the ballot. It has to go to the electors. This is not when somebody is temporarily appointed to fill a vacancy in an elected role. That's different. That's a different classification. But option B, clerks and treasurers are considered employees because the town board directs and controls their work. If you look at the three-factor test, they're going to meet those criteria. And the board can end their employment at any time. All right, deputy clerks and treasurers are also treated as employees, even if they're filling in for an elected clerk or treasurer. They work under the direction of the official who appointed them, but they can be assigned additional duties by the board that go beyond responsibilities of a clerk or treasurer. The clerk or treasurer who appoints them can remove them at any time as well. Now, firefighters are a weird one. Minnesota has a long tradition of volunteer fire departments, but the term volunteer firefighter is widely used, and that label can be misleading. In many cases, firefighters receive some form of compensation, if it's an hourly pay or pension contributions. Once that happens, the idea of them being purely volunteers becomes less accurate, especially when you're looking at things from a tax or employment standpoint. For tax purposes, firefighters working on for a township fire or emergency service are usually treated as employees rather than independent contractors. This is true even if they don't receive wages in the more traditional sense. The key factor is that the employer still controls how the job is done. Department decides who responds, who calls, sets work schedules, provides equipment, provides resources. So we're looking at that three-factor test again. Firefighters also don't have that financial risk or opportunity for profit in the way that an independent contractor would. Taken together, all of that three-factor test, they become more and more looking like an employee. All right, this one I get a lot. Are elected officials employees? I'll get a lot of questions. What is an employee? As a starting point, elected township officers, supervisors, clerks, treasurers are considered public officials, not employees. That means they're elected by voters, they're not hired. They don't work under traditional employee-employer relationships, and they have independent authority defined by statute that other employees kind of don't have. So in many everyday governance situations, they're not employees. However, certain laws treat elected officials as if they are employees for specific purposes, and that's where it can get kind of confusing. So, for example, wage and tax purposes, elected officials are generally treated as employees. Their compensation is subject to payroll reporting. So even though they're elected, the IRS views them as employees for tax handling purposes. Also, workers' compensation, right? Elected township officers are usually covered as employees to ensure that they're protected from injuries while they're performing their elected duties. Of course, you should always confirm coverage with your insurer, whether that's MADIT or somebody else, but that's generally how that rule works. And then para, of course, some elected officials may qualify for para, and others may be excluded depending on their hours or earnings. If you want more details on that, you should contact PARA. It's very fact specific, so it's important to verify eligibility if you're not sure. And then employment laws can be confusing too for a lot of people. In certain employment-related laws, elected officials are considered employees, and for some, they are not. So, for example, anti-discrimination statutes, whistleblower protections, paid leave, elected officials are considered employees for those purposes, but for earned sick and safe time, for example, they're specifically excluded from that law. So it really can depend. When somebody says, what is an employee or elected officials employees, it depends on what law you're talking about, because they all each have their own individual definition of what an employee is and what that means. So sometimes they're included, sometimes they're not, because elected officials are kind of a funky third option as far as employment. All right, elected officials performing extra work. So it can get tricky when an elected official decides to perform paid work for the township, because how you classify them, again, depends on the specific work they're doing and the nature of that relationship. The person is considered an employee when carrying out their official duties, right? We just talked about that. But sometimes an elected official does additional work where things can get more complicated because the extra work might fall under different classifications, like an independent contractor. So when an elected official is paid for work outside of their role, the board needs to look closely at the situation, and that three key factor determine whether that person should be classified as an employee for their additional work, or if they are a contractor for that other work, right? If someone is, this comes up when someone is handling manual labor, operating the township vehicles or equipment, or serving as an election judge. Those aren't part of your elected positions itself. Notably, election judges are always treated as employees. So if a person is also does employee work, they would be, election judge work, they would be an employee. However, for things like manual labor, equipment operation, those kinds of things, it usually, obviously depends on the specific details of the work, but usually that is an independent contractor. That relationship would be an independent contractor. And if a supervisor is performing that work, then you would want to go through the process of allowing that person to have that contracted work. And that process is laid out in our document C6000. And if you want more information on that, I won't jump into that too much right now. But if you want to have a contract with the township that you could otherwise give to somebody else, you need to follow specific steps, as in passing a resolution, voting unanimously, and then submitting an affidavit with your claims for payment. So that's all laid out in our document C6000 if you want to take a look at that. But that's everything that I have on employees. The key takeaways today, the classification is based off of reality. It's not based off of the title that you give a person. Most workers will default to employees, and it's your job to figure out how to get them out of there if you want to do that. Use the three-factor test, including behavior control, financial control, and what that relationship officially looks like. Be careful of misclassification. It can be expensive and risky. And then when in doubt, make sure to consult with your attorney or a tax professional to see where that person ends up. All right, stop sharing. All right, does anybody have any questions? No, all right. Well, thank you for joining me today. I hope you guys all have a wonderful afternoon. Enjoy the weather. It's supposed to be very nice tomorrow, so get out there, enjoy some sunshine, get some vitamins. We all need them after that long winter. So have a good week, everybody.